with case number 18CA011315 entitled The State of Ohio versus Antonio Veira. Each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. Just let me know and I'll keep track and interrupt you maybe to let you know if you're getting close. The oral arguments are recorded and posted on our YouTube channel, so we ask that you stay behind the front podium here and keep your voice up. I don't believe there's any children involved in this first case, but if there are, we use initials rather than names. And the panel has read the briefs, and we are ready to proceed if you are.
Thank you, Your Honors, and good morning. May it please the Court, and I would reserve 5 minutes for possible rebuttal.
Very good, thank you.
If it pleases the Court, Kenneth Liu on behalf of the appellant, Antonio Veira. As this Court may recall, this is the second time we've been here on this particular case. The case was remanded for ruling on the merits of the expungement request. We did have the hearing. The judge did deny the request, and we are now here asking the Court to reverse the trial court on an abuse of discretion standard. I'm fully cognizant of the standard to be applied here for the Court to determine whether the trial court's decision was unreasonable, arbitrary, or unconscionable. As stated in my brief, abuse occurs when the result is so palpably and grossly violative of facts and logic that evidence is not the exercise of will but the perversity of will, not the exercise of judgment but defiance thereof, not the exercise of reason but rather passion or bias. Arbitrary has also been defined by the case law to be without consideration of or regard for the facts and circumstances. A number of the cases cited talk about when trial courts review expungement or sealing requests, an inquiry is made as to whether the court fairly considered all of the rehabilitative efforts and the other factors contained. It's my position that the court merely stating, as it did in this decision, that it having considered the facts and circumstances, the trial court found that the motion was not well taken. It's my contention that merely stating that the court has considered those facts and circumstances are insufficient in this case. As the Ohio Supreme Court has stated, that the expungement statute is an act of grace created by statute. It's remedial in nature. State v. Rossi states that it must be liberally construed to promote their purposes. And I think other cases cite, interesting, we have sin, punishment, atonement, and forgiveness. The basic premises behind what we know as the sealing or expungement statute. And I think it's also worth noting the changes in the expungement statutes over the years, and there's been a recent change to expand the definition of eligible offenders. An offender can now expunge up to 5 felonies under certain circumstances. I think that reflects the trend in the legislature and the laws to expand the category of persons entitled to expungement. And I think that falls in line with the cases that I talked about, that expungement should be liberally construed to promote their purposes. And the purposes are when someone has sinned, they're punished. When they're punished, then they have to atone. Then, or we can call that rehabilitation, then forgiveness, or the sealing of a statute, to give someone a fresh start, a clean slate, to move forward in life, recognizing that they made a mistake, they've atoned for that mistake, they've done certain things to be rehabilitated, and now that we should give them a second chance.
Counsel, let me ask you a question. I might have some of the same concerns about the actual entry that you do, but I want to jump back a step first. Do we even know whether the trial judge found your client to be an eligible offender?
I know in the first go-around, we'll call it, I don't think that the court merely stated that it did not have jurisdiction to entertain the motion, and that's when the first appeal happened. I don't know that in the entry itself that brings us here today, I don't believe the court made that finding that he's an eligible offender. You can see the journal entry that's attached. It's a short journal entry. The court gives a little history of the case. Just recites 2953.32C1A through E, and then the only finding the court makes is, having considered each of the factors and the record before it, finds defendant's motion to seal the record of conviction is not well taken and is denied. So to answer your question, I don't believe the court specifically made a finding of eligibility.
So wouldn't he have had to have done that before he got into those weighing factors? You're kind of concentrating on the weighing factors,
Yes, I am.
saying we needed to know what that thought process was, and you're,
I guess we're assuming that the court has made the determination he was eligible, or perhaps taken the fact that this court in the first appeal sent it back for determination on its merits.
but in the first appeal, we specifically said we take no position as to
Right.
whether he's eligible.
Correct.
We just said he wasn't excluded as a matter because of that particular crime.
That is correct.
Go ahead,
So
I'm just asking,
I'm
wondering
thinking
out
forward
loud.
to your question, what might possibly be behind your question, are we putting the cart before the horse here? Is this an issue that the trial court, didn't address and needed to address? I'll leave that to this court's, judgment. But moving forward with my argument here, I would submit that when we look at the overall picture, that the trial court's denial of this motion in and of itself is unreasonable, and particularly in light of the fact that the court's entry is merely giving lip service to having considered the factors. And I'd like to just court to consider this. In 2005, when Antonio Veira was 22, he was in the chat room, on the internet, in his home, engaged in conversation with a Vermilion police officer posing as a 15-year-old, suggested a place to meet in the jurisdiction of the Vermilion police. He met as soon as he pulls into the parking lot, which is literally 100 feet inside the jurisdiction of the Vermilion Police Department. He was arrested, indicted, prosecuted. At his second pretrial, he pled no contest to the indictment. The pre-sentence report was ordered and issued. He came for sentencing on felony 5s, no prior record. He didn't get community control sanction. He got a prison sentence at the very first, at his sentencing. And mind you, this is a first offender, 22 years of age, no record, pled at his second pretrial, and he doesn't get community control sanction. He gets 6 months.
At any point in time, was he ordered to do treatment, and was that discussed with the court, whether or not he successfully completed that?
It was not at any part of the record that I saw. So he came for his pre-sentence report. He was sentenced to the 6 months. While in prison, he did do a pro se motion for judicial release. That was denied. So he served his full 6-month sentence. He was then released on 5 years of mandatory post-release control. I'm assuming, I don't know that it's part of the record, I didn't represent him at the time, but I'm assuming that post-release control in any sex offense would have probably required some treatment. What we do know from the pre-sentence report that was done as part of the expungement request, that he successfully completed his 5 years of PRC with no violations. He also successfully registered for 10 years as a registered sex offender, as this was an offense under Megan's law at the time. He was a sexually oriented offender, first offense, 10 years registration. The record also reflects that he successfully registered for 10 years with no issues, no violations. So adding to that, he led a law-abiding life. When we made the first application for the sealing or expungement, I believe 2017, we're now about 12 years removed from the offense. He'd been out of prison for 11 plus years. He had lived a law-abiding life, no further problems with the law. He had gained some employment, he had furthered his education, he had done many things that would fall into the rehabilitative standards and scheme that what I talked about earlier should be looked at. For the trial court to give lip service to all that, I submit reflects an unreasonable position. Now, did the trial court come out and say on the record, well, because of the nature of the offense, I'm denying this? No. I would certainly, and the state even argued in the state's opposition to the motions to seal along the way, they took great pains to point out the nature of the offense warranted a denial of a motion to seal. Well, as this court knows, and we all know, that is not a basis to deny an appeal, or excuse me, a sealing or expungement is the nature of the offense. The trial court failed to take into account all of the rehabilitative efforts that Antonio has taken along the way, and merely just denied the motion, saying it's considered the factors. And some of the cases cited in our brief, I think, goes to some of the courts struggled with, is that trial courts, fail to take into consideration all of the rehabilitative efforts that a particular person.
Counsel, I'm sorry for interrupting, but I know
Before you answer that question, so you can determine how long you want to take answering it. You're at 5 minutes right now, so go ahead, ma'am.
5 left?
5 left.
Okay, very
Okay,
good.
I'll be quick. So one of the issues though is that there wasn't any evidence really presented at the hearing. That's what the prosecution is saying in his brief, that your burden, your client's burden.
Yeah, I saw that in their brief, Your Honor. I'd simply state this. The trial courts here, when an application for expungement is made, they refer the case to the probation department, PSI unit. And the court ordered that on February 10th. So the defendant, whoever makes an application for sealing, they're ordered to go to the PSI, pre-sentence investigation unit, probation department. They do a pre-expungement interview report similar to a PSI for a sentencing. This is the same unit that does the PSI, so they have the original PSI. They do a report that includes the background check, the summary of the case, the defendant's performance on probation, prison, PRC, Megan's Law. They do a complete investigative report to the judge, also a social history of the defendant that outlines his work history, his educational history. This report goes to the trial court.
Is it part of the record?
It's not made part of the record. The courts make it available for us to see. I'm allowed to look at it, just like a PSI report. They're kept in the judge's offices. They aren't made part of the appellate record.
Did you
So-
take steps to make it part of the appellate record?
I did not. I assumed, and think one of the first things the judge says when we come in for the oral hearing on the motion, the judge says, in addition to the PSI report that you've been given the opportunity to review, is there anything you'd like to state for the record? And at that point, then I went into the advocating on behalf of my client, given the factors, the facts, the information that I know is contained in the PSI expungement report. So to answer Judge Carr's question, I don't think that's a valid argument for the state to make, given the fact there's a PSI done, there's a full report given to the trial court prior to the hearing even being held that is taken under account. And in that PSI report is all the factors that I raised in my oral advocating on behalf of my client, all of the rehabilitative things that he's done, the fact that there are no further offenses pending. What the PSI report would do is if there's a pending, or if you pick up another case along the way, they would say, well, he has another case along the way, there's other things that make him ineligible, et cetera, and the court would have that. Well, the court had all the information about Mr. Veira and all of his rehabilitative efforts, his PRC performance, and so on and so forth, that I don't stand up and represent everything that I know the court already has. I just make the arguments based on what I know is already before the court.
2 minutes and 10 seconds.
Thank you.
Good morning, Your Honor.
You'll have 15 minutes.
Thank you, Judge. Brian Murphy, Assistant Prosecuting Attorney with the Lorain County Prosecutor's Office. Your Honor, I believe on behalf of the state, the first issue that the court must consider is whether this court or really any court had any jurisdiction, of course in this case the trial court, to consider the application. And as the state has asserted to you, the attempted unlawful sexual conduct with a minor conviction precludes Mr. Veira from even applying or having an attempted application.
Matt, hasn't the Ninth already ruled on this, though? Hasn't the Ninth already ruled on this and found that, that attempted unlawful sexual contact with a minor does not preclude sealing?
In Mr. Veira's prior appeal, in his prior appeal,
I thought there was a case, State versus AV, where this court held that. I could be wrong.
State versus AV is
Mr. Veira, yes, okay.
first appeal to the court, which was actually based on revised code section 2953.
But didn't we hold that?
A2.
Different.
A2. This one is under A6, a felony with a felony conviction with a victim under the age of 16. So,
Question though,
yes,
what you're saying now, what you're arguing, and I believe that's your first assignment of error.
correct, Judge.
Did you argue that to the trial judge at his second hearing?
State I was not there, but
And
as a
the
representative of the
state.
state and the team though, correct. The state did not make that argument, Judge.
So this would be the first time.
Correct, Judge. But what I'd offer to the court on behalf of the state is that this is a jurisdictional argument. The case law says that the court can't even consider the application if the person does not meet all if the person's precluded under any of the, I believe it's 6 points under 2953-36, which is weird because they come after 32, so the jurisdictional issue comes after the merits. But if the person's precluded under any of those, is removed from being an applicant, that the court can't even consider the application. So to consider the application, you have to overcome that jurisdictional barrier. And can you really waive that jurisdictional issue? Can this court, under a de novo review of whether the person's an eligible offender, you get to look at that new, Judge, the panel does. You get to look at that new. This is a de novo review. You don't give any deference to the trial court's findings. You get to look at this new and whether this person was eligible.
So the state presumably didn't argue the, I'm going to call it the juvenile section the first time because it wasn't truly a juvenile because the police officer was an adult.
Well, but...
I'm talking the first time.
Correct.
So now the argument is...
I don't want to speak why something
No, I'm
was
not
or
saying why, but...
was not done. What I differentiate, though, to the court is the importuning statute, which involved the police officer. Now, the attempted unlawful sexual conduct with a minor conviction had that background with the police officer, but the victim, and you know, every crime really has some sort of victim. Even attempted crimes have a victim. In this case, would have been some person between the age of 13 and at least 13 and not yet 16. It's not a police officer. The importuning statute actually specifically addresses that the person is a police officer posing as a person, I think, under 13 or 13 to 16. So this is, but this is a de novo review, the jurisdictional issue. Now, did the trial court expressly consider the issue? The record wouldn't say that, but to reach the merits, the trial court would have had to say that the person was eligible.
But it's, I guess I have two questions. But in regard to reaching the merits, the trial court basically just says, I've looked at each of the factors.
Correct.
So he says, he didn't say specifically whether the applicant is an eligible offender, make that first determination.
Right.
So wouldn't that perhaps go to whether he's an eligible offender?
I think the trial court had to have in some way determined he's an eligible offender.
So what I'm saying is, with your argument about jurisdiction, does that go to A, or is that you're saying they're not even allowed to apply?
Does it go to A of?
A, which is the statute that says the court has to determine the applicant's an eligible offender, obviously first before anything.
Correct. I can't say that a person can't apply because, to find that there's no jurisdiction quite possibly might require an application. So I'd never go so far as to say that the person can't apply, but that the court can't consider that application on the merits.
Okay, so you're really not talking about subject matter jurisdiction then, right?
No, clearly the court has subject matter jurisdiction over an application. In this case, the subject matter, I think, would probably be basically limited to whether the felony conviction occurred in the state of Ohio. I think that's pretty much the limits on the subject matter jurisdiction. If the conviction were in, for instance, the state of New Jersey, Ohio courts wouldn't have any ability, so.
Absolutely, so that's why I'm getting back to Judge Callahan's initial question, and that is, I don't understand then why the state can't waive that argument if it's not truly a jurisdictional issue.
Well, as it's framed under the law is that the court can't consider the application, is what in Menzie in the 10th district held is that, or at least noted, the court can't even consider the application. So if the court can't consider the application, to me that becomes a jurisdictional issue. Perhaps over that person at that moment. I don't know that it's a subject matter jurisdiction, because subject matter jurisdiction to me says, does the court have the authority to consider the application? And if it does, it's just, I don't know how the court considers a jurisdictional issue without the application coming before it. And the other view is that this also really has been portrayed as not an adversarial proceeding, but an information gathering proceeding. So it's not necessarily, first of all, with regard to any waiver, Judge, the state clearly didn't go in and intentionally relinquish any
I
right
understand
there.
that, so I should have been talking forfeiture.
Well, and if you want to claim that there was a failure to raise or object to it, can by virtue of the state failing to object to it, what this court would have to say is, well, the trial court had an opportunity to determine if this person was an eligible offender under 295336, and in our particular case, A6. And whether it did or didn't do so, that despite the person being otherwise ineligible, even if you found this person ineligible under A6, the state forfeited the right to argue this, but this issue, or to raise the issue, but it's incumbent upon the court in these proceedings, I think, the trial court, to determine the eligible offender. Did it do so expressly? Does it need to do so expressly, explicitly in an entry on the record? look, clearly it didn't do so. I can't contend to you that it did.
We could circle back to my very first question. The trial court could, in fact, have found exactly what you're arguing,
It could
and
have.
we have no idea.
It could have. Yeah, I suppose it could have found that he was, and I want to just clarify, it could have found him ineligible under 2953-36A6, right, is what you're saying?
That's
We just
exactly
don't know. Well, but what I'd say, Judge, is if it found him ineligible under 2953-36A6, then it would not have had to issue a journal entry saying, I went to 2953-32, the C1A through E factors. It would have just issued a journal entry that said under 36A6, the person's ineligible. But ultimately, what this state will fall back on with this first argument is the court, if it doesn't have the authority under the statute, under the 36 portion of the statute, to grant or deny, then it doesn't have the authority to then consider the merits.
Counsel, I'm sorry to do this to you, but this is going to be one of the questions
Sure.
going through my mind, so I might as well just ask you. Sounds to me like you're arguing plain error.
You know, as I considered this brief, it did come across in my mind as this plain error. I don't know that it's, and I don't remember why I ultimately forewent specifically arguing the plain error. I think what it really comes down to is it being a non-adversarial proceeding and an information collecting, that it's not on the
So you don't have a duty to
state.
even raise those issues, you're saying?
Correct. The burden's really on the applicant.
Well, and the other thing that goes along with plain error, if it's plain error, would you have a duty to appeal or cross appeal?
And
That's what I didn't want to really get into, but.
well, and that's possible. Yeah, and as you say that, I think that might have been something that did come across, is that if we're asserting the error, then we have to appeal the error. We're just answering the fact that it was not granted or was denied.
Your argument is you're just giving other grounds that it could have been denied.
Correct.
Got about 2 minutes left.
Going to the merits, Your Honors, frankly, look at the record. Just look at the record from the most recent trial court hearing. What was the trial court supposed to put into an entry as its reasons for denial? There was no evidence set forth by Mr. Veira during the hearing. It's his burden. If the state went into a motion to suppress hearing and said, well, we've written briefs for you, and judge it on that, then we clearly would not have met our burden. PSIs are produced by Mr. Veira's own admission in preparation for sentencing, but there's still presentations made to the court. In death penalty cases, there's multiple reports produced in preparation for sentencing, but defendants still put on mitigation, right? As far as that expungement report goes, the record is, that part's not in the record. So it's not for you to consider. In fact, with regard to the post-release control, we have no idea if there were violations or not, because it's not part of the record. The burden, even going over the jurisdictional hurdle, the burden was on Mr. Veira to show evidence of, in a hearing, not just through the statements of an attorney, that his interest in having the record of conviction sealed was equal to or greater than the state's interest in maintaining it. You look at cases out of the 10th District, going back 25 years now, Haney and Newton, Schaefer out of the 11th district. And that's that the applicant has to present evidence to support the application, testimony, affidavits that are sworn to. And
Counselor,
that's
you're at
just
15
not,
minutes.
that's just not before the court. So we'd ask that the court find that the trial court either was correct in not granting or correct in denying the motion. Thank you. Or
Thank you very
application.
much. And rebuttal, 2 minutes and 10 seconds are left.
Thank you, Your Honor. I think it's worth noting, on March the 27th of 18, you'll see a state's opposition to defendant's motion for sealing record of conviction. The prosecutor's response to this motion for sealing, and on the first page, the state posits that the court has found that the particular offenses of which defendant was convicted make him technically eligible to have his record sealed. However, the state argues that sealing is not and should not be automatic. A person convicted of a crime has no substantive right to have a record sealed. The state then goes on to talk about the nature and circumstances of the offense, and particularly the public's right or now or desire to know about this conviction. So the state's objections all along the way was not that he's not eligible, not that the court doesn't have jurisdiction, but that the nature of the offense is the reason why the motion should be denied, and that the public's right to know is the reason that the motion should be denied. Without regard to the fact that the legislature has determined that under Megan's law, there's a 10-year period that the public has a right to know, and that was complied with. The state would posit, and it has posited, and its only objections to this motion all along the way was that the public needs to know. And that was really their main argument, the nature of the offense, the public's right to know forevermore. And I submit that the argument that was raised in the brief about A6 has never been raised. It was never raised at any step of the way until the appellate's brief in response to this most recent appeal. So I would ask the court to take that into account. And also take into account, if it's going to address the merits of that the victim of this case was an adult police officer. The victim of this case was not a child. And I don't think the court can ignore that fact as well. So submit all the arguments presented here before. I would ask the court to grant the appeal.
Thank you both for your presentations and arguments today. The court will take the matter under advisement and issue a decision, which the clerk of courts will mail to you on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website. Again, thank you both for your arguments.